Okay, we're going to get started. First, I wanted to thank the sponsor of this room. It's MGO. MGO is the people-friendliest way to experience the world of movies and TV. We hope you get what you want to watch on any screen. Just think of us as your entertainment wingman. For more information, please visit us at www.mgo.com. And actually, they're very nice. I visited them at the booth, and they're giving away a TV at 7 o'clock, so pretty, yeah. Is this better? Okay. All right. Our next talk is software patents, who's behind the curtain. Our speaker is Deb Nicholson. She's the Community Outreach Director for the Open Invention Network. I'll give you over to Deb.
Thanks. Oh, thanks. So I'm going to talk about kind of like what is going on in the field of software patents with regards to policy. There weren't really any votes. Like, I don't get to say like they did an awesome thing anywhere in any legislature, so it's going to be light on that. But the good news is that there's been a lot of thinking about how to deal with software patents, trolls, excess litigation, and that sort of thing in the last year and a half. So I'm going to do kind of a whirlwind tour on that. Good. Okay, so I'm going to start with where patents come from. This will be really quick just so everybody, I know not everyone in the room is probably an attorney, or I'm not an attorney, so we'll do a real quick tour, but and then kind of talk about what the situation is now and what some of the solutions that are being floated are. So the first question that we sort of want to grapple with when we think about patents is, how do we measure innovation? So the patent system is supposed to help us promote innovation. And unfortunately, I think this word has kind of two ideas coupled inside of it. It comes from the Latin word new, like for new stuff. And so a lot of times when we talk about innovation, we talk about new ideas, which are abstract. But then when you hear more like kind of corporate speak about innovation, we're talking about products. So what's good for products isn't necessarily good for ideas. So when you hear the word innovation, I want you to kind of think about whether we're talking about like, wow, that's a cool idea, or, oh, that's a neat product. So you would maybe think about it this way, like the idea person, the innovative thinker, might say, you know, I bet this thing would go faster if we did something with the aerodynamics on it. So that's just an idea. The inventor would say, I did some math, I figured out what would make it aerodynamic, and now the thing is faster. And then the innovative marketer or the monetizer, right, would say, I bet we could get people to pay more for a faster thing. So those are all like kind of three different places on the chart of innovation. So I talked a little bit about patents, products, or ideas, and you know, we're going to talk a lot about patents. So one of the things that kind of clouds, like when we're talking about patents on products or patents on ideas, especially with regards to software, is what's called functional claiming. So that's like kind of a legal way of saying that software patents tend to be on, I will do this thing, as opposed to, I did some work and figured out how to do this thing, or I built something that fixes this problem. The idea for a software patent can be as vague as, I noticed a problem, and I bet we could fix it with software. So that's, you can see where that can end up with a lot of fuzzy thinking, fuzzy math, whatever you want to call it. It's tricky because we're not supposed to have patents on ideas, but let's see how we kind of got there. I'm not going to talk about the whole legal history. So in 1787, patents for science and the useful arts are added to the U.S. Constitution, and at that time, something like this, like the patent on the grain elevator, and this is like a 5-part machine. It's a giant, monstrous thing. Like you can see it, you can touch it, you probably live in it, but it's important. It's sort of the precursor to the assembly line. So it's like not only is it a giant idea, it's a giant pile of devices that all work together to like feed people and make more bread. The USPTO is established in 1790 to promote industrial and technological progress. So far, I'm with them. That sounds like a great idea, right? And then 1799, we start getting into like more like abstract stuff already. So the first financial patent is granted for an invention for detecting counterfeit notes. So you can see we go pretty fast. False teeth, we still have lots of patents on devices. Rubberized fabric, the first lawnmower. The patent numbering starts. The first patent is issued for the locomotive steam engine, patent number 1, which I'll get back to a little bit later on. The railroad industry is actually an example of where we had patent speculation before. So people like to think like, oh my gosh, the software patent problem, it's worse and it's completely unprecedented and we've never seen anything like this. And in fact, actually, we've seen it a bunch of times. There were, patents issued on brakes on trains, which of course you can't have a train without brakes, but we'll get into a little bit on how they solved that. And then plants, I'm not really going to comment on that except that I think it's weird you can patent a plant. And then the first software patent was granted in Britain in 1966 for efficient memory management for the simplex algorithm. So that was like the beginning of the flood there. In the 1970s, rapid growth in the category of pharmaceutical patents. However you feel about that, a lot of people believe that the pharmaceutical patent system is great, it saves lives, and it spurs innovation, et cetera, et cetera. The point here is that it's very different from software. 1998, the Federal Circuit affirms the patentability of business methods, and this sort of opens the floodgates for a lot of vague, abstract patenting. So you see the very next year, the single-click patent is issued. Does everyone know which one that is? Yeah, okay. I know, it's like, I can't even, I wonder if there's a patent on the idea of thinking of something that broad. But anyway, I don't want to give anyone, you can't use that. Anyway. And so then in the last decade or so, we see lawsuits by non-practicing entities, more familiarly known as trolls, increases 5-fold. And I'll show you guys some numbers on that in a little bit. So more money, more problems. Unspoiler alert, I don't know. I've kind of lost track of whether I read a lot of this stuff or in comparison to everyone else and how much everyone else is reading, but just so we're kind of on the same page. Patent suits are costing us a lot of money. The activity is increasing, not decreasing. They are not spurring innovation, and developers are fed up. So this is from James Besson. He's a scholar in Boston, and he writes a lot about NPE lawsuits in specific, but also general patent policy. Annual wealth lost from troll suits was $80 billion when he looked at this in 2011. So that's every single year, troll lawsuits, $80 billion. And it's not, the trolls aren't actually getting the $80 billion. They're only getting about 10% of it. The rest of it is lawyers' fees, money on the ground from lost opportunities, stock prices plummeting, loss of consumer confidence, all of these other things that make having a giant troll lawsuit to deal with suck for your business. So this is from Patent Freedom. You can see that's a really intense curve. So these are suits involving non-practicing entities or trolls, like I said. Patent Freedom is more polite than I am, so they always say NPEs. And then the number of patent actions, and this includes not only trolls but also practicing entities, which I'll get into why sometimes that is also a problem. 4,015, and this is the highest number ever recorded. So, and that was in 2011. So that is a lot. Utility patents. So not only is the lawsuit activity increasing, the number of patents itself is also increasing. Again, with kind of a scary whoop, sort of number. So if people have questions, or I am going too fast, or there's words on the screen that don't make sense to me. Oh, there we go. So this takes out design and plant and those kinds of patents. So it's supposed to be for useful devices or processes. So of which software is in there, as are backhoes and false teeth. It's the whole spectrum. So spurring innovation. So one of the reasons that we might put up with all of these $80 billion worth of money flying around was if it was doing some other good for us. If it was serving some other actual purpose, like spurring innovation. And from all we can tell, that is not what's happening. So one example, I was just talking with a friend of mine, Jonathan Nadeau, and he said, yeah, we were talking about e-readers for the blind, and he said, yeah, there's just 2 companies in that field that make e-readers, and they both kind of work on the same type of technology. It's like, you know, a little ping noise that happens in response to HTML code. And there's not really another way to make e-readers for the blind. So there's 2 companies in that field. The slightly larger one sued the smaller one, hoping that they could knock out their competitor, right? And this is troubling, one, because there's only 2 in that field already, and then also because the software is already very expensive. It costs about $1,000 a copy, and the audience for that particular software is people who are visually impaired who overwhelmingly tend to be unemployed, 80% in the U.S. So what happens is the state council for the blind in whatever state you live in buys a copy of the software for each of the people in their area that needs it, because they hope that folks can get to a place where they'll be more self-sufficient and be able to do some kind of work where like their visual impairment doesn't impact their ability to get work done. So 2008, Freedom Scientific sues GW Micro. 4 years later, the patent is overturned. The courts decide it was a pile of junk, but there was a bunch of cases, a lot of money on the floor, and in the intervening time, like no improvements or real feature adds happened to either e-reader. So who wins? Well, technically GW Micro, right? So because they won the suit, but they spent a lot of money to do it and couldn't innovate while they were doing it. Freedom Scientific doesn't win. The visually impaired community doesn't win, and as I noted, given who actually buys the software, the taxpayer does not win. So I think we can say pretty safely that spurring innovation is not what's happening here. And so, you know, just this is the unfun for developers, but I think it also makes it especially burdensome for the free software community, because it means we spend time doing other things. So like rerouting around the fat patents in the kernel, or pulling out different code, or avoiding specific formats because they're patent encumbered. It makes it hampers our ability to give the world the best possible free software operating system. So while I would like the world to be more fun for developers, all of this is, for me, the bigger issue is that it impacts free software. So some of the more recent developments: patent aggression entities are getting bigger. The targets are getting smaller, and I don't mean so small like, you know, like you should expect a letter tomorrow or whatever for yourself personally in your home. And then the stack versus special sauce, so the kinds of suits that are being brought. So this intellectual ventures is probably the largest patent massive aggregator, we would call them. They have thanks. So intellectual ventures has 30,000 to 60,000 patents, 1,300 shell companies, and they have relationships with around 400 different universities. So we're not entirely certain what those types of relationships are, but a lot of times it involves like your students invent something and you can use it, but then we also have a license to it because we've given you some money. So like they're trying to get licenses on inventions before they're invented. And then they, you know, we know what they're doing with their licenses. It's probably not written into their university contracts that they're going to use them for aggression, but we know that's what intellectual ventures does. The thing about the shell companies is troubling because you don't always know that you got a letter from intellectual ventures, because it'll be some area of theirs that you've never heard of. And then it means that your avenues for redress are limited, because if it was intellectual ventures doing all these things, then you could say like, hey, wait, you're bringing all these frivolous lawsuits, and they'll say like, oh no, that was 1,299, 98, and that one was 1,297. Like they're all separate corporate entities. So it makes it very hard to figure out how to make them accountable for their activity. This is from Colleen Chen. She's great, actually. She writes very nice, readable stuff on this topic. So she said here, patent trolls are increasingly targeting users and adopters. And like I said, I don't mean individual users in their home, not like the download people, but like like banks that are using databases or things like that. So because they actually don't care if they piss off customers. So whereas a practicing entity, even if you sue your competitor, you're not going to sue the people who are using it, because if you sue the people who are using it and then you're like, now you can buy stuff from us because we just sued you and and our competitor's gone, they're going to be like, yeah, screw you. But trolls don't actually care because they don't sell anything to anyone. They just bring lawsuits. Like I said, the last year and a half saw a lot of different ideas and thinking about like what could be done in this area. And I'm going to go over kind of by like how what sort of entity would be looking at the particular area. So before we do that, like I just want to go over like sometimes I talk to people and they're like, oh, we should just like make like patents, like patent law better, and it's the problem is not really the current standard for patentability so much. It's like the way it's being applied. So currently, patentable subject matter, it's already supposed to be new. It's not supposed to be something that people are already using. It's already not supposed to include algorithms. So the statute itself is fine in that regard. Like I said, it can't be something that everyone else is already using, and it can't be obvious to someone else in that field. So if you were to say try and take out a patent on underwater basket weaving, which sounds crazy if you have never done basket weaving. Has anyone done any? All right, I'm the only one that went to the weird colonial camp as a kid. That's fine. All basket weaving is done underwater. It sounds funny because you picture the person underwater, but the basket is underwater because it keeps all the stuff pliable. So in someone in the field of basket weaving, they would be like, duh, you can't have a patent on underwater basket weaving because it's all underwater. So that's like just to kind of give you an idea of what we mean by non-obvious. And then useful. This is not so germane to software. It all tends to be useful, but the Patent and Trade Office has struck down things where they're like, I'm going to do things with magnets, and it's like, no, you can't do like magic with magnets. You can't have a patent on that. So judicial solutions. We'll go through those first. The thing about judicial solutions is you have to bring more lawsuits. Or the way that judicial change happens is they set precedent by ruling differently on different suits. So the way that we would go about that is to keep watch on lawsuits as they go through the courts, and then try and push the courts to make good precedent in that on that particular case. And so, like, we've already had a couple of different cases where the community has filed amicus briefs, which is like a friend of the court. They're like, we're not one of the two parties involved, but we have an interest here, and that type of thing. So, and lawsuits, as we mentioned, are expensive. So one of the things that we might push to sort of stop up the damage here is to try and entreat the court to lower the plaintiff's incentive to sue. And there's sort of two things there. The first is to make it not so profitable. So right now, the lost sales rubric is used to award damages. And so, like a thing like a smartphone that probably has like thousands of different ideas all bundled into it. If you are suing on just one, it might represent like maybe 0.3 or something, or 0.03% of the actual phone or something like that. But then the damages that get awarded are be like a couple of dollars per handset. So the amount of money to be made versus like what is actually, like people aren't buying a phone because they're like, oh, I really appreciate the new way the battery snapped in. Like that's not representing like 15% of their purchasing decision. So we could push the courts to do a little bit better of a job in that regard. And what was the... we could ask them to set precedent that better upholds the existing statute. Bilski and Prometheus and the Alice corporations, cases are where we've already tried to do that. So in the most recent one, the Alice case, where it hinges on like a lot of stuff with flowcharts and ideas, but then on a computer is what is being tangled with in that particular case. And so it seemed pretty obvious from the existing statute that that would not be a patentable subject matter, but there's a particular district in East Texas where people bring these suits and they think everything sounds like a good patentable idea. So they did a very Clintonian, like, what is in regards to deciding that that was still patentable. So, so again, like, we would have to work and get something brought in a different district probably, or push the Supreme Court to be more definitive in their review of the lower court's decisions. We could also ask them to set precedent that treats software patents differently than other patents. And so that, they do that sometimes already with, like, certain medical things. You can't, for instance, sue a surgeon for doing a procedure that saved a person's life. So we do already treat some classes of patents differently than other patents. So, okay. So then the other thing people always wonder, so like the courts, we had to pass a law, like for the children, right? And this is where a lot of the academic activity has been, as far as like, we could get Congress to do something. Congress, Congress ain't cheap. And they did already do something. The America Invents Act it was sort of like, we have to do something to, help innovation. And what it did do was change us from a first to invent to a first to file, which sort of harmonizes with the European system. They took tax methods, which is sort of like a code word for not patenting cheating on your taxes. And then they created more opportunities for third-party prior art submission, which is good. What they didn't do was ensure more funding for the U.S. Patent and Trade Office, which is a problem because they already, on the average, look at each patent application for about 18 hours. So that's like, oh, I got this thing, and it's written in this crazy legalese, and then I've got just like 18 hours spread out over the course of a couple years to make sure that nobody else already did this thing. That would have been a great thing to do. That didn't happen. So we could ask them to improve the America Invents Act. They probably are going to improve it a little. They have some inconsistencies with grace periods and things, like basically the equivalent of like egregious typos and things like that. I don't know if they're going to revisit that issue. It took a lot of time to get like a pretty watered down bill as it was. We could also ask them to get rid of patents altogether, or just get rid of software patents. That's I think getting rid of patents altogether in all fields. We have what's called a unitary patent system where we mostly treat all patents the same, and so I think trying to get rid of patents altogether, just the amount of power and money in the pharmaceutical industry would make that just impossible. Like, it'd be like we're already trying to wrestle with a couple of tigers and then insulting the Incredible Hulk's mom for good measure, just to make sure that you make it a real pain in the butt for yourself. Or just software patents. We could ask them to include something more like the European system, where they do have software patents, but it's a little bit narrower. It has a slightly more, you have to show a little bit more of something that's actually been done. So the trick with Congress, so if we ask them to stop issuing software patents, it would just going forward. It would be hard for them to say all of the old software patents are invalidated because of folks that hold software patents now. So that would be a lot of work. We could also make the plaintiff pay the legal fees. So this is a funny backronym, actually. It's saving high-tech innovators from egregious legal disputes. So basically, this would be, when you kind of think about these different solutions, it's like, is the problem the patents, is the problem the trolls, or is the problem the kinds of suits that are being brought? So it depends on how you ID the problem. if you idea the problem as like just the trolls, then this seems like a pretty good idea. It means a lot of troll suits lose if they actually go to court. A lot of them don't go to court because it's expensive to go to court. But this might, for a certain size business, they might be like, well, I bet we could win this, and especially like it seems worth the gamble if we know that we'll get the legal fees back at the end of it. Not all businesses would be willing to make a 4-year bet on like a ongoing legal dispute. It could also have the unintended consequence of affecting sometimes like a legitimate suit. So or discouraging a legitimate suit. And then the last kind of idea that, or category of ideas on the legislative solutions, is that we could raise patent or maintenance fees. So we could make it more expensive to get patents, or we could make it more expensive to keep them through their whole 20-year life. And this sounds appealing until you kind of think about like who it affects besides trolls. Because like everyone's like, yeah, let's take more money from trolls. That sounds like an awesome idea. But then it also means that like other, it would be more expensive for other folks. And this could have like sort of a backfire situation where actual practicing entities have a software patent or some other type of patent on some things. They're paying the maintenance fees. They get more expensive. They can't afford them anymore. They sell it off, and then it ends up with a troll. And so, looking at how that might be done, we'd have to word it carefully. Yes. That is one of the ideas that's been floated also. That one of the ways that we could like ameliorate rather than just get rid of software patents is to have it be like 2 or 3 years, something that's more consonant with the industry. The 20 all across is sort of weird. Like in pharma, when you talk to folks over there that aren't at generic drug companies but are at the big name companies that do R&D, they're like, we would rather actually have like 25 years for pharma. And I'm like, okay. Right, they would like a longer term. It's because it's like people and diseases and a lot of different variables. It sometimes does take them like 18 years to get their idea to market. So then they have 2 years, and then the generic drug companies can start challenging their patent on the last 3 years. So it's like it can be very it's a very different release cycle than software. So and applying like the same brush to both fields is Right. Yeah.
We considered the idea that perhaps we should just try and get a law that says NPCs have understanding of prospective patent.
That's the troll. It stands for non-practicing entity. That would be tricky because then we would have to figure out how to like just say what a practicing entity and a non-practicing entity is. And some of the non-practicing entities are universities, like they're just doing research. So there's like another term emerging also where you have what's called like a patent aggression entity, and that's like to differentiate schools that are just doing research and have patents from trolls that are doing litigation as a business model. No one's drafted anything that would be a legislative solution like that, but it's an interesting idea. It would be a little tricky because of the shell game that I talked about with like all the different like kind of shell companies. So like, maybe like you're prosecuting a patent suit and you're not producing a product or licensing one. Right. Yeah. But who knows? Maybe like they sell a brick with like telephone written on it to like one person, and they're like, okay, we're practicing, now we're done. It would have to be stringently written. I'm just saying like capital is not the problem for trolls, and the amount of patents. It's they have plenty of money, they have plenty of patents. Right. Yeah. You would hope that would. They are making a lot of money. So like the desire to circumvent your loopholes is high. So anyway, so let's go. So as far as like agencies, we're all here. We're developers and people that care about free software. So why is it our job to think about these things? So policy solutions, like in a nutshell, like how can we get the USPTO to enforce the existing statute in a helpful way? Because we saw the statute itself is not terrible. It's not very specific about software or any other particular field of endeavor, but it isn't it isn't even being applied fully. So one of the things that we could do, and let me start with her name. A woman named Artie Ray. She had a post recently on Wired, and she said that we could do something like, or she suggested that we could do something like bioinformatics, which is basically like gene sequencing. And the Patent and Trade Office already has like a separate area that deals with bioinformatics because it's like the human body and technology like kind of tangled up together. And so they felt it was in the public good to make sure that we were really specific about what we're, not granting patents on people. And so for that specific field, they require written descriptions and definiteness, and that has like kind of a specific legal term. It means you can't do the type of functional claiming that I talked about at the beginning. Like you have to say like how you're going to do it, not just that you're going to do a thing. And then the definiteness is another piece where you actually circumscribe what is not covered by your patent, which software patents never do now. So that would get rid of a lot of the more like frivolous and vague and weird software patents if the Patent and Trade Office were to do that. So again, this would only affect patents going forward. It wouldn't do anything about like the next 20 years and all the patents that already exist. So we could a lot more resources for looking at software. This is what they've done with business methods because they're sort of like vague and it's like, well, let's have another person take a look at it. That costs a little bit more money. It's a little bit more time, but they want to make sure that they're not like providing patents on stuff that is really silly and dumb. So they do that for business methods. So that is another way that we could kind of get the USPTO to do a better job. Yeah. Like, that the examiner at the Patent and Trade Office is actually... Oh! Hmm. Yeah, the jury selection process is already pretty like specific. Like I think it's supposed to be like a slice of the general population, so we would have to and as Bradley is saying, I think Okay, I don't think we're gonna get a constitutional amendment to say that for software patent suits we can have different kinds of juries. As fun of an idea as that is to entertain, not that I would even want to serve on such a jury. I just right. So well, yeah, that's exactly. Again, this is probably also big picture and unlikely to happen, but the way that the USPTO currently operates is they assume validity, so the burden of proving that something is novel and whatever is, it's flipped. So the U.S. Patent and Trade Office has to prove that it's not novel, as opposed to putting the burden of proof on the patent applicant. Does that make sense to people? Okay. Yeah, that's another tricky one where it's like, could we talk about like just the department at the U.S. Patent and Trade Office that looks at software patents, say like, just because of the way this industry is. I mean, it would be maybe like we could do that in conjunction with the written descriptions and the definiteness. So, yeah. Mhm. Mhm. Right, and then for software, they don't even really have journals to look at, which is one of the yeah. Anyway, and then lastly, the FTC, which is charged with looking at trade and regulating trade and making sure that patents to 75% of their applicants. And so that's dangerous, kind of way to incentivize the Patent and Trade Office. They had some other ideas, looking at like what would keep businesses and customers in balance, like their different needs. And they have written this a couple of times. They talked a little bit about like what it would take to bring sort of an anti-competitive lawsuit, like which is a little tricky because when you're looking at trolls in particular, they're suing all different industries, and then what happens when you look at competitors suing each other? It's a little bit hard to prove whether they, like, hey, you didn't really think that patent was valid. You're just trying to knock down your competitor. So they talk about like how long and difficult it would be to do that kind of a process. It would need to be like sustained activity, like, if you saw like two businesses in one specific field suing just each other over and over again, or one suing just the other over and over again. So they admit that they're sort of a slow lumbering force. But their report references another report that they did just 5 years earlier where they said, like, just revisiting how we know this is a giant problem again. So there's awareness, and there are some solutions in there too, but I think the best and most important one is changing the fee structure. So what about community solutions? Okay. Actually, freedom is free, but it does take work. Just like passing laws and bringing lawsuits takes work and money. It does require some work. So, community solutions. I work at the Open Invention Network. I don't want to have you think that that's I just happened to mention that one. We have a defensive patent pool where if you're working on Linux or GNU or Android or related free software, then everyone puts their patents in a pool and agrees not to sue each other. The other activity that we work on is identifying relevant prior art. This is exactly the tactic that the railroad associations took when they were getting sued on all the little bits and pieces of trains. They were like, well, let's all of us who actually have trains meet and talk about what we could do together and make sure that people who don't have trains but are trying to get patents on parts of trains can't get them on things that we're all already using. So they identified a body of relevant prior art so that the USPTO would know, oh, this is already part of trains. This is already obvious. This is not new. This is something people are already doing, already using. And this guy who does not have trains can't have a patent on it. So that it works for trains. Remains to see if it will work for software. I hope so. We're giving it a whirl. There is also a new, Jennifer Urban wrote a defensive patent license. She admits it's still kind of in beta. It's basically, she describes it as copyleft for patents, and it's sort of like across all fields of endeavor. So everyone, what are you doing, Brad? Anyway, so there's a Wikipedia article on it. I don't know if that is going to take off. And then I think this is a very important thing that the community can do on this problem is to continue to build awareness and draw attention, because I think what happens now is, if you're not involved in building free software, then your friends and relatives who don't really pay attention to this stuff, when it comes across their, sort of field of attention, they see two massive software companies that have a lot of money suing each other for a lot of money. That's just an astronomical number. And so the amount of sympathy and tears that they oh, it seems like Bill Gates lost some money again, is very low. So making sure that, when you have opportunities to talk to people, that isn't really the only, that's not the only kind of suit that's happening. That's not the only impact that it's having. So, let's see. So these, as I mentioned, Colleen Shen, if you want to take a look, this is from late last year. This one is specifically about patent trolls. And then this is a book looking at all the different like sort of judicial types of reform. And so if you do like reading about this stuff, these are all pretty readable and good places to start. So those are my picture credits. And then, oh, did I do? Okay. And then if you have questions, I will do questions. Should I take Bradley's first? He did raise his hand first. Go ahead. Mm-hmm. Mm-hmm. That actually is not happening. That is the point of the defensive pool, is that they're not suing on Linux and related free software. Which is really old and then wasn't brought. Right? But they sent the first letter on that. Anyway, that is like a, yeah. And is that the only example you have? PlayStation is free software? So GCC is in the Linux system definition. So how far back are we going? I'm not telling you that I think IBM and Sony have been like all puppies and unicorns for the entire corporate history. I'm saying that they've agreed to not be jerks in this area at this time, and and they've contractually agreed to that. Right. And that's what got them to sign in, because they're both very large companies with a lot of different interests. No. I didn't say that. I said that they have defined the stuff that they will not sue on, and if we keep working with them, then we may be able to grow that definition. I think like asking like, did they... Okay. Does anyone besides Bradley have a question? In the back in the red, and then I'll come over here. Right. Right. Well, so there is already a treaty, sort of, it's called TRIPS. I haven't read it all through, but it's trying to make sure that there's some harmonization. Unfortunately, like, the U.S. is kind of the bully at the table on a lot of those international treaty things, so, like, I don't know that we would get, like, the sort of, like, small, whatever, European country that's doing everything, like, the way that we think is awesome to be able to outweigh that influence. As far as borrowing solutions from other countries that are good, like, one that I didn't mention that was floated was having an innocent kind of user defense. So the courts could toss out cases where it's like, that's not the maker of this thing, they're just a user, you can't sue users. So like Germany, the United Kingdom, France, and Japan all have that type of defense codified. So So there are some other things that we could borrow like that. That's just the first one that comes to mind for me. And then sorry? Oh, yeah. So China is not. Yeah. Well, China's a whole other. I'll go here and then here. Yeah. Right. So Linux Defenders is, when I said we're working on identifying relevant prior art, Linux Defenders is a website that organizes that specifically for like Linux and related software. So there is a lot of that happening, and it's sort of picking up, especially as the America Invents Act provided more opportunities for third-party prior art submissions. So that's like a more, it's basically, they said we're going to do more looking at that. Which is good, but then developing the actual prior art is, like I said, it's some work. So, but if you have ideas and you want to submit prior art is free to submit. So that's, which compared to patents is a bargain. So, the other thing I'll say about prior art is the earlier on in the process you submit it, the easier and the cheaper it is to do that. So, here and then behind you. Yes. I don't know what the number is for I don't know what the number was for last year, but I don't think it did this, unfortunately. Maybe. Yeah, I don't know the answer to what the number looked like for this year, and obviously I don't know what's going to happen next year, so but I haven't seen any indication that that's the case. Yeah. Behind. Mm. Huh. So like maybe saying like, hey, you guys want longer and we want shorter. Like let's go together and do that. I think that yoking those two different interests together would be difficult to get people excited about. Like some people would be like, great, but it would be a very thin slice because I think a lot of people who despise software patents aren't that jazzed about pharmaceuticals. So if it was like, oh, we're gonna go and like tell, so it's yeah, I think that would be a tricky coalition to build and hold together. Hmm. Perhaps. Yeah. I mean, I think they don't care about it one way or the other. They just are vigilant whenever they hear conversation like patents are terrible. We should get rid of them all. So like, I think if we were more surgical and specific in our conversations about like we hate software patents like specifically, and we want reform on that specifically, then we at least would not create an enemy over there. So, any other questions? Oh, right. Sorry. Against intellectual monopoly? Okay. Right. Yeah. No, I understand. Like, it's if I understood more intimately what was going on in pharma, then I would feel more qualified to have an opinion as to whether, like, it's egregiously remiss of me to not have a position on that or not. But I also think that it will take longer to get reform that is industry wide than industry specific. So it's like it's a balance. Right. Well, and the claims don't. Yeah. I'm gonna take one more question in the back, and then we can all pile in. I didn't know if you had something specific, and then. Mhm. Mm. Right. Okay. Yeah. All right. I'm gonna thank you guys. You can stay and continue. Thanks.